I want to get straight to CBS News Chief Legal Correspondent Jan Crawford, who has been reading through the opinion. Jan?
Well, Major, we just got this ruling within the last couple minutes. The justices in a 6-3 vote, a decision written by Justice Samuel Alito for the other 5 conservatives, are striking down a second majority black district in Louisiana, ruling that state officials focused on race, and that amounted to an unconstitutional racial gerrymander. Now, this decision is a major one under the Voting Rights Act. It will go well beyond Louisiana. It's going to make it, based on what we're seeing so far, it will make it harder for state officials to draw up these so-called majority-minority districts, which have been used for decades and have increased black representation and minority representation in Congress. And it also, I think, will call into question about a dozen or so existing majority-minority districts, mostly in the South. Now, those districts, as you know, Major, have been a way for Democrats to pick up seats in some of those states, those red states in the South. So this ruling is a win, I think we can say, for Republicans. But legally, this is a Supreme Court that, going back 20 years or more, has been saying in case after case, a consistent line of cases, that the Constitution is colorblind. And that's why we've seen the Supreme Court do things like throw out affirmative action in college admissions. This line of cases very consistent with the court's ruling today. What about the midterms? I think this ruling coming today, 6 months after it was argued back in October, may come too late to have an impact on these upcoming midterm elections. I think the focus will be going forward, limiting states from considering race when they're trying to consciously and intentionally draw up districts to increase minority representation. That means, Major, that you might not have as many of those kind of ink-blocked states, or states that have districts that zigzag like a Z, where they go from, like this one did, from Shreveport all the way down 250 miles to Baton Rouge, scooping up black voters along the way to, again, pick up voters to get enough black voters there to have that majority. So I think, you know, that will restrict some of those those districts for sure. Looking at this decision, it's 37 pages long. There is a dissent by liberal Justice Elena Kagan that appears to be longer than the majority, and it looks like a barn burner. She is saying that today's ruling will is gutting the Voting Rights Act and will call into peril some of the accomplishments that we've seen over that historic 1965 law that really dismantled Jim Crow and systemic barriers to voting for black people in the South. Of course, the Supreme Court today, as they have in recent decisions on voting rights, is saying the country has moved past that. It's time to stop intentionally focusing on race. And as Chief Justice John Roberts said in a case back in 2007, the way to end discrimination, race discrimination based on race, is to stop discriminating based on race. And this Supreme Court, with those 6 conservative justices, believes that racial preferences, whether it's in affirmative action, whether it's in redistricting, that can amount to unconstitutional race discrimination, Major.
Jan, I'm going to let you continue to read the opinion, and if there's anything else that strikes you, please let me know. In the meantime, I want to bring in Jessica Levinson, CBS News legal contributor and Loyola Law School professor. So this is Section 2, Jessica, of the Voting Rights Act. And then in 1982, Congress also passed an amendment to the Voting Rights Act, making it clear that some voters could, if they felt that the district lines were extremely discriminatory to their interests, bring legal action. So there's 2 aspects of congressional intent here, yet the Supreme Court said, we've taken that into consideration, but we still believe that process violates the Constitution, and the Voting Rights Act Section 2 has gone a bit too far.
That's exactly right. And I want to echo what Jan said, which is that this is a case where the Supreme Court, once again, a majority has said, don't use race. We've seen this when it comes to admissions in higher education. We've seen it in other circumstances. And here again, we have the court saying, in order to comply, in this case, with the Voting Rights Act, and you just mentioned Major Section 2, which prohibits diluting somebody's ability to vote on the basis of race and other categories. In this case, the court is saying the way to ensure that we can satisfy the Voting Rights Act is not to make these race-based lines. As Jan said, we have a serious division in the court in the sense that we have Justice Kagan saying that this is the incorrect interpretation of the Voting Rights Act. And then, in fact, when you think about this landmark piece of civil rights legislation, that one of the ways to ensure that you are complying with this legislation is to allow the use of race when you draw lines, when you draw these legislative lines. I think Jan was exactly right to point out this could have implications potentially not for the midterms, but certainly going forward, where you're going to see that states can draw these district lines, I think, using slightly different criteria and frankly being less worried about complying with Section 2, because I think that the big takeaway here is that it's going to be hard to bring successful challenges under Section 2, again, of that landmark civil rights legislation, the Voting Rights Act.
And it's worth pointing out that Section 2, unlike other parts of the Voting Rights Act, were permanent and national in scope. Some elements of the Voting Rights Act were much more geographically specific to remedy past abuses in certain areas. Section 2 applied permanently and nationwide. That's why this is such an important ruling. I want to turn now to our chief White House correspondent, Nancy Cordes. Nancy, Jan referred to some of the potential political implications of this. Pick it up from there.
Sure. So I think that there is a concern or a question about whether this ruling is going to kick off Chapter 2, if you will, of the gerrymandering arms race that we've been watching play out across the country since last year, when President Trump first said that he thought that Texas should redraw its legislative maps. And the reason that that was controversial is because typically states only redraw their maps once every 10 years after census.
We're just hearing a CBS News special report. The Supreme Court voting 6-3, striking down Louisiana's new redistricting maps. Of course, much more of this coverage to come throughout the day.
Right, they're striking it down based on race, saying race should not be a factor when you are drawing out these maps, though Justice Elena Kagan saying in a very long dissent that this could likely gut the Voting Rights Act of 1965, and many believing this could certainly have an impact on midterms.